And yeah, welcome. We're going to be speaking on a very, very interesting topic today, and that's the topic of international divorce. I've asked Chante to come in because she has, she's done more of these blooming things, contested and uncontested, than I like to admit or mention. So she's going to be talking to us about a few interesting things that she's encountered. We're going to go through some practical examples. We're going to do mostly the bare basics of it today. So I don't know if we're going to be 2 hours, 3 hours, 6 hours, or 1 hour. Probably going to be about an hour and a half to 2 hours. It's the first time we run this presentation. And this is my daughter, Emmy, everybody. So hello, everyone. Are you going to wave?
Hello, Emmy.
Yeah, you wanted to be here, now you're famous. Sorry about that, guys. So, yeah, international divorce is a very, very, very interesting topic. It's a very, very difficult topic, unfortunately, because of the difficulties between jurisdictions, etc., which we'll go through. But hopefully, today on this nice, warm, chaotic Friday, we'll all be able to share some interesting information, and we can all go away having learned something. Right, some housekeeping. Please use your real name for our register purposes. Please save comments and verbal questions for the time slots provided. I see quite a few people who have registered haven't logged in, so it's a nice small group today. Come here, my lovey. So we don't have to be too formal in terms of asking questions, etc. As you can see, we're having casual Friday here, Emmy and I. Please feel free to type questions, comments in the chat box at any time. We'll deal with as many as possible. Please be respectful. We obviously welcome comments and dissent. Please just keep it respectful. Please avoid hate speech, victimization, etc. And please also don't record or distribute the contents to persons who did not attend. We'll obviously distribute it to all of you, but this is mostly our IP. All right, so what we are going to deal with today, it's quite an interesting load of information really that Chante's put together for us. We're going to look at what really is an international divorce. When we talk about an international divorce, what is it? We're going to look at jurisdiction, and then under that, the issue of domicile. What is domicile? It's one of those things where it's obvious, but it's not obvious. And it is quite a problematic thing from time to time. Then we're going to talk about the proprietary consequences of divorce. We're going to talk about the legal processes, and then we're going to do some examples and FAQs. One of the things we're also going to touch on, which we haven't put on the slide, we are going to talk about kids in international divorce and the implications of the Children's Act in terms of the whole issue of international divorce. So let's get into it. By way of introduction, let's talk about what we refer to when we say international divorce. And we've put a very, very short description here, which basically just says an international divorce ensues when either one or both of the parties are outside of the borders of the country of their residence, domicile, or origin at the time of the divorce proceedings. So anything that is dealing with nationals of one country dealing with a divorce in another country, we deal with international divorces. We deal with it in terms of the law, we deal with it in terms of administrative processes. So there are quite a few things that we need to really grapple with in talking through it. Now, there are generally, for us in South Africa, there are 3 circumstances that we will deal with when dealing with international divorce in a South African context. Let me just admit Alfred. Alfred, welcome, welcome. Always good to see you. Right, so scenario number 1, which we will deal with, is if party number 1 is in the RSA and the other party is abroad. One party, in other words, in South Africa, one party outside of South Africa. Scenario two is when both parties are outside of South Africa. You guys see I'm like on my toes. We're going to do a jig now while presenting. And then scenario number three is when both parties are in South Africa, but they are expats of another country. For example, a couple from the UK who would have gotten married there, immigrated to South Africa, and want to get divorced in the South African context. Now, there are a few problems when it comes to international divorce, and these are not an exhaustive list, but there are things that you need to consider when you deal with international divorces. Keep these factors in the back of your head because they are somewhat problematic. The first problem that we are faced with is conflict of laws. For example, in South Africa, we have three matrimonial property regimes: in community, out of community with accrual, out of community of property with the accrual. In most EU countries, it's completely different. In England, for example, you don't really have a very formal system of a matrimonial property regime. The court makes an order that it considers just. If you look at Zimbabwe, they still rely on the Matrimonial Causes Act, which when the marriage dissolves, it must put the spouses in a position as if the marriage had not been dissolved. In Australia, and Chante will tell you a story about this matter she dealt with, she just doesn't know it yet, where our client was an Australian expat, got married in South Africa, signed an anti-nuptial contract in South Africa, instituted divorce in South Africa, then moved back to Australia, then moved back here. His wife stayed behind. He sued her for divorce here. She sued him for divorce there. And we entered into a huge mudslinging battle with the other side. Which court has jurisdiction? Then furthermore, Australia says, well, I like this anti-nuptial contract. I'm going to roll it into a spliff and smoke us all with it because it doesn't mean anything to me. I do not recognize your third world South African laws down under. So conflict of laws is a big problem that we deal with in international divorce. Then we deal secondly with the issue of jurisdiction. Jurisdiction means which court is clothed with the authority to hear the matter, which court may adjudicate on the matter, in other words. We're going to deal with that. Then obviously logistics. Someone is living in South Africa, they want to divorce their spouse who is on tour in Afghanistan, for example, when they were still fighting over there, or Syria, or someone who has immigrated to Ethiopia or the UAE, etc. Getting the documents delivered, getting documents back, court appearances. Lee, who's obviously not with us today, told in one of our other lectures a story about her client who took the ex-husband who was living in Dubai to maintenance court, and this was during lockdown, the travel arrangements that had to be made, etc., etc. Then we look at enforcement. Enforcement is a huge problem. Let's take maintenance, for example. South Africa makes a maintenance order in a divorce proceeding in respect of kids. Dad, or mom for that matter, immigrates to another country. How do you enforce that order? If they stop paying maintenance, how do you actually enforce it? Now, there are a few solutions, which we're going to be looking at, some in fair detail, some others not so much, but be aware that these solutions are imperfect solutions. They don't cover all eventualities, and Chante will tell you guys later about a very interesting case that's crossed her desk, where the laws and the conflict of laws was something that just, there was no viable solution for these people in terms of the cross-border situation. The country in that case was South Korea. But these are the solutions that we have at the moment. We have treaties and conventions. For example, we have the Hague Convention on Civil Aspects of International Child Abduction, the Hague Convention as it's affectionately known. We've got the Apostille Convention, which we'll deal with a little bit later, and I'll explain it a little bit later if anyone is not sure what the Apostille Convention is. And then we also have legislation. In South Africa, we have two specific ones. We've got the Reciprocal Enforcement of Maintenance Orders Act and Reciprocal Service of Civil Process Act. Arda, there is no formal definition that I'm aware of where a court has defined it. This is basically between Chante and I. We've put our heads together and said, look, in our experience as legal practitioners, this is how we define it. You'll also see if you go and look at, go and Google international divorce lawyers. People are very, very scared to touch it because it's a bit of a romp slump, you know. So we have a dearth of case law, unfortunately. And so long story short, where did we get the definition? We thumb-sucked it. Right. Then we go on to cooperative governance between countries. And a very, very good example of this is, for example, the European Union, where they have this cooperative framework between various countries who are perhaps in the same bloc or whatever the case may be, and they deal with it in such a matter. And then in terms of South African law, we have the solution of edictal citation and substituted service, which Chante is going to discuss in quite a bit of depth. So, when we talk about jurisdiction, how do we establish that a court has jurisdiction? And Chante, can I hand over to you, or shall I do one or two more slides? You warmed up, you ready to go?
You can do these two slides.
Bang brook. All right. Okay, so when we talk about jurisdiction in terms of divorce matters, we turn to the Divorce Act of 1979. And the, oh my goodness, that's not good, Audra, if you can't see my slides. Is anyone else not seeing the slides?
No, I can see.
I think it might be a setting on your side. I will distribute the slides, however, so don't worry, you will get a PDF and you will get the recording with the slides. All right, so the Divorce Act really makes provision for two scenarios to be clothed with jurisdiction to hear a divorce. Number one is if the person is domiciled in the area of jurisdiction of the court on the date on which the action is instituted, which is very, very important. As we know, especially our contested divorces can really turn quite a long time. Then the second jurisdictional requirement in the alternative is if the person is ordinarily resident in the area of jurisdiction of the court on the said date and has been ordinarily resident in a republic for a period of not less than 1 year immediately prior to that date. So the first question, whether a South African court can hear a divorce, funnily enough, has nothing to do with nation of origin. It has nothing to do with what passport you are on at that stage. It deals with one of two issues, the issue of domicile or the issue of ordinarily resident. Amy, what are you doing? You want to tell everyone what you're doing? You're making a big noise is what you're doing. Sorry, guys. So we deal with the issue of domicile versus ordinarily resident. Now, if we extrapolate from that, the factors that we need to deal with, we have to really first off explore the concept of domicile. So if I can go back to this slide over here with jurisdiction, ordinarily resident, I mean, it's very simple. Do I stay there? Have I stayed there for a period of not less than 1 year prior to that date? That's very, very simple. Domicile, however, is a bit more complex. So domicile is a two-pronged concept. it really consists of two different things. Number one is domicile of origin. Number two is domicile of choice. Domicile of origin deals with your place of birth. If I am born in South Africa, my domicile of origin is South Africa. This is not contained in any legislation. We find the concept of domicile of origin in our common law as well as in case law. Thereafter, we look at domicile of choice. Now, domicile of choice is a bit of a tricky one. It's regulated by the Domicile Act of 1992. The Act raises a few more questions than it answers, but it is a framework to work from, an imperfect one, but a framework nonetheless. And it deals with the issue of intent. Now, Section 1 of the Domicile Act is really our Bible when it comes to domicile of choice. It basically says the following: every person who is of or over the age of 18, either a major, sorry for the corgi and the toddler in the background, and every person under the age of 18 who by law has the status of a major, excluding a person who does not have the mental capacity to make a rational choice, shall be competent to acquire a domicile of choice regardless of such person's sex or marital status. Now, the sex or marital status came in 1992 in this legislation specifically because it was shortly after the drafting and the promulgation of the Matrimonial Property Act. If some of you will recall, prior to the MPA, we had what was known as the marital power, where the husband had to assist the wife in all sorts of administrative functions and. So they felt it reasonable to put this in, and I think it follows. Any person, regardless of sex or marital status, can acquire a domicile of choice. Then we look at what is a domicile of choice and how do you get one? So subsection 2 of section 1 tells us a domicile of choice shall be acquired by a person when he is lawfully present at a particular place and has the intention to settle there for an indefinite period. Are you coming to brag with your ice cream? Okay, let me open it for you while I talk to everyone about domicile. What do you have to add about domicile, Emilia? Nothing. No, fine. Right, go keep the doggies busy outside. There we go. Lekker in die Wesrand, roomys for breakfast. Okay. Domicile of choice consists of two elements. It's a two-pronged question that needs to be asked. The first is the physical element, which I've highlighted here in red above. And the second is the mental element. Now, I've copied and pasted here to an extent from the Act itself. The requirement in subsection 1(2), and please stop me, guys, if I'm going too fast. If a person is lawfully present at a particular place and has the intention to settle there for an indefinite period, they acquire a domicile of choice. Now, we have two sub-elements of the physical element. In other words, lawfully present at a particular place. Number one is obvious. They must be present. If you're not there, you don't have your physical presence there. Number two, your presence must be lawful. And here we are talking about things such as visas, passports, work permits. In other words, an undocumented immigrant in South Africa, of which we're seeing more and more these days. They cannot acquire South Africa as their domicile of choice in terms of our law. Why? Because their presence in South Africa is not necessarily lawful. That's the physical requirement. That's very simple. Then we need to prove intention. Now, intention is a difficult concept. I can say to you that I have the intention to keep you here until 5 o'clock. I can say that, but do you know that that really is my intention? Am I being facetious in saying that? Well, I hope I am. But how do you see what is going on behind someone's eyes? How do you know what the intent is? So you look at observable and provable facts when disputed. Chante will tell you later about a matter that she dealt with where our client said he had every intention to settle in South Africa indefinitely. And his wife, who was sitting abroad, said, but hold on, you've still got 2 immovable properties, an airplane, a luxury vehicle, and in this other country. So I call bullshit. You are not really wanting to settle there. You're just saying so. So you look at provable and observable facts to infer the intention. And unfortunately, once again, it's an imperfect solution, but it is a solution nonetheless. And then the third aspect that we really look at with domicile of origin is that it must be for an indefinite period. Does it mean that you have to sign a contract, notarize it, and say that I'm going to be here for life? Not necessarily. It means that you must be in a headspace at that stage to say, I have no intention of going home right now. I have no return ticket booked. I'm going to settle here for the foreseeable future. I think is a nice synonym to say, this is where I want to be right now. Obviously, it can change at a later stage, but if you have no intent of going home, then the intention is clearly to settle there for an indefinite period. Then we deal with people who cannot acquire by choice. It's the last bit of technicality, then we're going to go into some practical examples. Domicile of choice obviously can be attained by anyone over the age of 18 or any other person who is a major, if they're under 18, except for people who do not have mental capacity. So if we talk about persons who cannot acquire a domicile of choice, we're talking very simply about kids under 18, as well as people who do not have mental capacity. And then we look at the place to which they are most closely connected. Now, what the heck does that mean? It's a factual determination. Where are they residing? Where are they connected? You know, they could be residing, for example, in the UK. However, they were removed forcibly from South Africa 2 weeks prior and taken there. Then they might be connected mostly with South Africa. It's a factual determination. And then it also talks about definition of a child and children. The parental home is generally, unless it's proven otherwise, considered to be the child's domicile. Now that also becomes a factual determination insofar as a child could be temporarily taken to one parent's home in a divorce. That is a parental home, but is it their domicile if they'd only been there for a very short period, if they are being held there against their will, etc., etc. Very interesting factual determinations. Now, this is something that can be quite troublesome. Laren, very warm welcome to you to the session today. This can be problematic if one looks at the technicality of this whole issue of the requirements for a domicile of choice. So what Chante has very kindly done is she has provided a couple of nice practical examples for us. So I'm going to actually just quickly make Chante a co-presenter. No, Chante is a presenter, aren't you? Yes, I think you are. And she is going to chat through the issue of some practical examples for us. Chante, so over to you. Just see if you can take control of the PowerPoint on your side, please.
Okay, I'm quickly checking now. Let's just see. Okay, great.
You've got power. I'm going to wrangle the toddler for a few minutes. Please do excuse me. I'll be back.
Okay, thanks, Merv. Hi, everybody. So for you who came in a bit later, my name is Chante, and I am co-presenting with Mervyn today. So basically what I'm going to do is I'm going to take you through a few examples and deal with some of the processes and what edictal citation and all of that is. So first off, I want to actually start with something that we call a lacuna in our law. Now, for you who don't know, the word lacuna is actually just a very fancy word that us attorney uses to describe where there is a missing part or a hole in the law, right? So unfortunately, in our law, we actually have a lacuna when we are dealing with international divorces. And the reason why I'm saying that is let's rather look at the scenario. So the scenario reads, it says, wife and wife were married in terms of a civil union in Cape Town. So both wife and wife immigrated to South Korea, and they both have the intention to reside within South Korea forever. So they wish to get a divorce, but Korea, so South Korea, does not necessarily recognize same-sex marriages. So the big question that we have here is, can they get divorced in South Africa? The short and simple answer is unfortunately no. And the reason why I'm saying that is that neither party is domiciled or ordinarily resident in South Africa. So this is really where domicile plays a big part. Now, if you can recall, Mervyn had just now spoken about domicile and the intention of the parties on where they wish to reside. So in this case, unfortunately, it is very, very clear. Neither the wife nor the other wife wants to return to South Africa. They both want to keep on residing in South Korea, meaning they are choosing South Korea as their domicile. So in this regard, a South African court will unfortunately not have the necessary jurisdiction to divorce the parties. Now, this scenario that we've presented to you guys now is actually something that happened to me. I had a client who contacted me saying, look, we want to get a divorce. We were married in Cape Town. You know, it was a civil union, so same-sex marriage. We want to get a divorce. South Korea says we can't get divorced here, so can we come get divorced in South Africa? Now, as I've said, it's not going to be possible for them to get divorced in South Korea, but because they're not domiciled in South Africa or ordinarily resident in South Africa, we don't have the jurisdiction to get them divorced either. So we're sitting with a case where a party and another party wants to get divorced, but they can't get divorced where they are staying, and they can't get divorced where they are married. So this is what we are calling a lacuna. So at this stage, unfortunately, the only way that we would be able to get the parties divorced in South Africa is if the court makes a ruling that, for example, the Divorce Act needs to be amended to make the necessary provisions for a party in this, in this scenario, that they can indeed come and get divorced in South Africa. My opinion at the end of the day is, if you were married in South Africa, why would you not be able to get divorced in South Africa? But once again, that's only my opinion, So does anybody have a question regarding this at all? Going once, going twice. Okay, sold. Alrighty, let's look at the first example. So we're going to run through some examples now. We're going to look at some scenarios that deal with jurisdiction and whether our courts can indeed divorce parties. Now, this first example reads that husband and wife were married in community of property in South Africa in 1997. However, in 2017, they obtained a working permit for 4 years to work in New Zealand. Husband has every intention of returning to South Africa. However, his wife does not want to. So can a court actually get these parties divorced? Short and sweet answer, yes, the parties can get divorced because the husband wishes to return to South Africa. His domicile of choice will be South Africa and not New Zealand. He's only working in New Zealand at this stage, right? So once again, domicile of choice will definitely play a big part. Mervyn?
Muted. Sorry, I see we've got a few hands. Do you want to finish this example?
Oh, great. I missed those ones. Thank you.
No worries. I think finish this example and then we can quickly go. I see Arta's got her hand up and I see Anin's got her hand up.
Okay, wonderful. Okay, great. Okay, so where was I? Okay, so domicile will always play a very big part when deciding if a South African court will have the necessary jurisdiction or not. The fact that the wife in this scenario does not want to return to South Africa will not make a big difference in respect of the jurisdiction of the court. The reason being, one, that the Divorce Act states that either or both parties need to be domiciled or ordinarily resident within the jurisdiction of the courts. In this scenario, the husband will be domiciled in the jurisdiction of the South African courts, and therefore the court will be able to divorce the parties. Alrighty, okay, that was example 2. So example 1, anybody having some questions? I think let's start off. Anine, if you want to start off. Can't see who's holding up hands.
Otherwise, I go. I don't know whether.
Yes, I think.
Let's rip.
Yeah, sorry. I just. It's very interesting, I must say. I just want to find out with regard to your first example. You know, you mentioned that, you know, you can't sorry, I mean, I should have responded quicker when you mentioned 1, 2, 3 gone. But, you know, the court can make a ruling, you know, the only option, you know, in that South Korean example is that the court can make a ruling with regard to the Divorce Act to actually rule kind of beyond that, because it's not catered for in the Divorce Act. It's a lacuna, so it's not catered for. But isn't it actually that that Parliament should deal with it? I mean, there should be a amendment with regard to the Divorce Act. I also don't know whether with this whole thing about trying to come to one marriage statute, whether those kind of things also will impact it upon that. It's not only marriage but also divorce and so on. But don't you think that it should be generally regulated instead of that the courts would deal with it? Because, you know, some people say, you know, the courts shouldn't create law, you know, that whole discussion about, how do you call it? Activism versus respect, you know, that whole thing. I don't know how you feel about that.
Okay, thank you so much, Ada. Okay, so in this regard, just for anybody who missed it, so long and short is, you know, when I was dealing with the first scenario, the Lacuna scenario, I indicated that the only way that we will be able to fix this is if the courts actually take a step in and, we say that the court needs to come in and say, listen, the Divorce Act needs to be amended. Okay, so we need to look at that. Now, in this, what Arda is saying now is, shouldn't it actually be the Parliament who actually comes in and says, well, this needs to be amended? So Mervyn, just correct me if I'm wrong, but my understanding is in this regard, the only way this will come under the radar of a court and then the Parliament is if a party actually has the mullahs to take this matter to court and say that section 21A and 21B or whatever the case may be of the Divorce Act is not necessarily constitutional because of the fact that it doesn't make the necessary provisions for this lacuna in our law. The court will then make an order to say, look, I make the order that this section is unconstitutional and I'm affording the Parliament 2 years or 60 days or whatever the case may be to come to an agreement to amend the law accordingly. Mervyn, I don't know if you want to add anything on that point specifically.
Yes, absolutely. So the courts obviously have the power to intervene when there are shortcomings in the law itself, specifically in respect of issues of unconstitutionality. So if we look at, for example, a very good recent example is the SCA case of President RSA and another versus Women's Legal Center Trust and others, the Muslim marriage judgment, where the court basically said, look, the fact that Muslim marriages are not recognized is completely unconstitutional. The legislature must now go back and fix it. In the interim, the following issues will apply. Now, the problem that we're faced with in this particular case, it really is an interesting one for debate for the following reason. It's not really our law that is discriminatory. It's the law of South Korea that is discriminatory. So are we able to establish a constitutional issue here? Now, how would a court interpret this? And they are, I think it's very, very open to dissenting opinions, but the court could say, well, yes, this doesn't take into account people who settle themselves in another country who want to get divorced in terms of South African law. Can it really say that? There's a corollary argument to that, or a converse argument to that, which says, well, you chose to go and settle in South Korea, knowing that they have antiquated laws insofar as same-sex marriage is concerned. So it really is a bit of a tricky one. I don't think particularly our law is overly, how should we put it, draconic or out of touch with reality as far as that's concerned. But this really is a problem, especially in cases where the parties have decided to settle there. To expect them to come back to South Africa could be very, very difficult. But that is a call that they would have to make. Just for those who are interested in this particular scenario, this is actually based on a real case that Chante had. We did a legal opinion for the parties. I think you worked with counsel on this matter, got a legal opinion for the parties, and they then, at the end of the day, when faced with the option to go to court to take this point and to try and make new law in terms of it, they elected not to, if my memory serves. Chante?
Yes, that's correct.
I hope that answers your question to an extent. Bloemfontein via Cape Town on that answer, but I think we're in Bloemfontein, I hope.
Yeah, no, thanks a lot. Yeah, and is it possible perhaps afterwards to connect, because I'm really interested in this case. Thank you.
Absolutely, yes. I've put Chante's contact details up at the end. You've obviously got my contact details already.
Yeah.
Reach out to us. We'd love to have a cup of coffee with you. I think our cup of coffee is long overdue already, eh?
Yeah.
Good.
Thanks.
Good stuff. Thanks so much. Chante, back over to you.
Thank you so much. I'm quickly going to take control here. Okay, there we go. Alrighty, so let's look at example 2. So example 2 deals with a scenario where husband and wife were married in England in 2001. They, however, came to South Africa in 2019. They are still domiciled in England. However, they have been residing in South Africa since 2019, right? So their marriage has now broken down. Both parties want to get a divorce. They come and see you and they say, listen, can I get a divorce in South Africa? The simple answer is going to be yes. And the reason why I'm saying that is that both parties have been ordinarily residents in South Africa. So remember, you don't need to be married in terms of the South African laws in order to get divorced here. It goes again to domicile or ordinarily resident. So in this scenario, both the husband and wife has been ordinarily resident in South Africa since 2019, which is more than a year because it's been 2 years. So in this scenario alone, they will be able to get divorced in South Africa. Now I'm going to be dealing with the proprietary consequences of the marriage since the husband was domiciled in England at the time of the marriage, but that I'm going to get to now. I'm not going to confuse you too much on this point as yet. So this is a very simple and easy example, and the next one is going to be similar and the same. It's not too hectic, but I don't know if anybody has a question specifically relating to this example. Okay, checking. Okay, great. No hands. I'm looking for the hands this time. Alrighty. Let's move on to example 3. So example 3 reads that a husband and wife were married in New York, and since then they have lived there. So the wife has decided to get a divorce. However, she's coming to South Africa on holiday for 6 months. So now she approaches you, and the big question, she wants to know whether she can get divorced in South Africa. So the answer is going to be fairly simple. The answer is no. The reason why I'm saying that is, 1, they were married in New York. They are still remaining in and staying in New York. She's only coming to South Africa on holiday for a period of 6 months. So if we look at whether she's domiciled in South Africa, the answer is definitely no. Whether she's ordinarily resident in South Africa, the answer is definitely no, because she's not here for longer than 12 months. She's not residing here. She's literally just coming for holiday aside. So in a scenario like this, the courts will definitely not have the jurisdiction to divorce her. So she's going to have to go back to New York after her 6-month holiday and institute her divorce proceedings that side. Alrighty, just want to make sure everybody's still on board and happy. Good, it seems that way. Alrighty, so okay, so here we are looking at the proprietary consequences of the divorce. So this is in essence the proprietary consequence of the marriage, which is governed by something that we call the lex domicile matrimony. And Mervyn, you can correct me if that pronunciation was not correct. But in essence,
language, no one cares.
Yeah, it's an old language. So this is basically the law of the place of domicile of the husband. So this is where the husband was domiciled at the time of the marriage. So what this in a nutshell basically means is that if a party wishes to get divorced and her husband was domiciled in another country, for example, England, at the time that the marriage was concluded, the England's law, so that country's law where he was domiciled, will determine the matrimonial property regime, will determine the proprietary consequences of the marriage. So just to explain this once again, so if husband was domiciled in England and husband and wife gets married in Morocco, for an example. Now they're living in South Africa. They've subsequently moved to South Africa. Now they want to get a divorce. The court will look at the place where the husband was domiciled, right, at the time of the marriage, which is going to be England. So in a case like this, if the parties want to get divorced, the South African court will be able to get them divorced this side because they're now subsequently domiciled here. But the laws that will govern the proprietary consequences of the marriage will then indeed be the laws of England. So therefore, a matrimonial domicile is, once it's determined, it cannot be changed, right? So if the domicile of the husband was England, that is the domicile. Now, this is actually a very nice thing because the husband cannot now go and change his domicile, you know, in a case where there's an acrimonious divorce and husband and wife is fighting. He can't go and change this domicile at a later stage in order for his wife to actually get lesser or less favorable rights in the property on whatever, you know, the case may be. So at all times, therefore, the domicile which the husband had at the time of the marriage would govern the matrimonial property rights. So regardless of where the parties reside when the divorce is instituted, or regardless of whether the husband has changed his domicile 7 times, you know, once the parties were married, the place where he was domiciled at the time of the marriage, once again, will govern the proprietary consequences of the marriage. Now, this also has a direct link to the domicile of choice and the domicile of origin. You know, it will play an important role because you're going to have to look at his intention, you know, at the time of the marriage to see that England was indeed his domicile when the parties got married. But that's just getting very complicated. So yes, I see, Mervyn, you actually made a comment here. I just didn't get it on this one.
You know,
Right,
this is going to be a hell of a problem. If we look at Frankel and we look at Sperling, what about same-sex marriages? How do you follow the domicile of the husband? It's simply not possible. Oh, sure, that question freaked Chante out to the extent that she ran away. Hopefully she'll join us again shortly. But guys, this is a very, very interesting paradigm to get our heads around. The fact that the law as it stands now, the whole idea of following the domicile of, or the domicilium of the husband, might be a problematic thing in future. Chante, I said to everyone, you got such a fright with that question, you saw me ran away.
I saw my left.
Sissy?
I am back now. Hello, everyone.
But I think this, Frankel and Sperling are going to get quite a lot of constitutional scrutiny from the superior courts. You know, one thing as an aside, in terms of anti-nuptial contracts, for those of you who do quite a lot of mediations, I see we've got once again quite a few mediators in. You will know that in most anti-nuptial contracts there is a clause saying that will be governed in terms of the laws of South Africa. Now, in our courts, at least, that is followed. Do you want to talk about your anti-nuptial contract with your Aussie divorce, Chante?
Yes, I think that might just be a good kickoff for us. So basically, I had a client who I consulted with, and he told me that, okay, long story short, because this is a really long story. He grew up in England, but he subsequently traveled through to Australia, where he was domiciled, right? Then him and his wife came through to South Africa. And during this time in South Africa, they obviously got married, right? So when they got married, they were talking about possibly, immigrating back to Australia, like moving back to Australia. And this didn't happen. So the parties got married this side. They signed an anti-nuptial contract, and they then subsequently moved to Australia. And then what happened from there is obviously the relationship had soured terribly. And then my client came back to South Africa. When he was here, we kind of consulted and we decided we're going to get him divorced here. This is his domicile of choice. He is present in South Africa. We're going to institute divorce proceedings this side. So we had to do something we call an edictal, a citation, and substituted service application first. Now, I'll explain to you in detail a bit later what that actually is. But in essence, what had happened is when we instituted the divorce proceedings this side, her attorneys in Australia ended up instituting proceedings that side. And like Mervyn said, they were basically telling us the ANC means absolutely nothing. So it was this big battle about who instituted the proceedings first, what court has the jurisdiction to divorce the parties, was my client actually domiciled in South Africa when he instituted this proceedings. So it was a terrible, like back and forth. We ended up having, my clients had South African attorneys, obviously us, and then we had to get Australian attorneys to fight the case in Australia, that side. And then she subsequently had to get attorneys in South Africa, and she had obviously her Australian attorneys. So, long and short of it is we did go to court to make a ruling on, because they'd raised something we call a special plea, saying that our courts does not have the jurisdiction because they instituted proceedings in Australia first. So we actually had to go to court, and just before, so the courts had taken a very long time to give us our ruling. I think it was about 3 months. But yeah, in that 3 months, the parties actually settled. So they settled their matter. So it would have been a very nice thing to, move through all the way. But when we finally got the court order, although we didn't agree with the court, and this would have been a nice thing to take on appeal, the court did say that Australia in this regard had instituted the proceedings first, so the matter had to proceed there, which obviously we didn't agree with. But yeah, here we are, the parties had settled, so it's the end of the matter, unfortunately. Don't know if you want to say anything else there, Mervyn.
Very, very interesting, just the inflexibility of the Aussies to actually recognize a contract coming from South Africa. And I think it highlights, folks, something very, very important for the mediators who are joining us today. When you mediate divorces that are going to have an overseas element, always get in touch with an attorney who knows this type of stuff to say to you, look, is this going to be valid in the country where the one party might be moving to? How are we going to enforce it? And that actually takes me very, very beautifully to the issue of children, and I've unfortunately put it on the slide, in uncontested divorce, actually children in international divorce. Have we got any questions for Chante and myself based on what we've gone through? You know, we've spent quite some time going through what is a very basic concept, and that's the concept of jurisdiction, patrimonial consequences, etc., etc. Does anyone want to get the discussion going on that before we start talking about kiddies in international divorce? Okay, no, we're having a nice slow Friday. Fastest fingers first as we go on. If you have any questions, you're welcome to type them as well. So, when we talk about divorce where there is an element of one party going to move overseas and there are kids, we obviously need to turn to the Children's Act, okay? And now, why we need to turn to the Children's Act is simply the following. Section 18.3 and Section 18.3c. Obviously, to those of you who have attended our Children's Act webinar will know this very, very well. To those of you who have not, please get in touch with me. I'm running it again on the 19th of November, and I would love to see you there. But let's quickly talk about Section 18.3 and specifically Section 18.3c. Now, this is something that can become fairly problematic to those of us dealing with divorces that span countries with kids. And 18.3 really deals with the issue of guardianship. What does it mean to be a guardian of a child? It means to administer and safeguard their property and property interests, assist or represent them in administrative, contractual, and other legal matters, or give or refuse the consent for marriage, adoption, and then the two big ones, departure or removal from the Republic, and consent to the child's application for a passport. Now, this becomes very, very problematic in a practical sense, and we've seen it a couple of times. For example, if one party is immigrating to the UK, for example, with a minor child, the UK are very particular with their visa applications, and in those cases, we've actually come to the conclusion that it's easy 18C3 and 4 responsibilities and rights just to enable the other party, that side, to take the necessary steps. From a practical sense, for example, in terms of 18.3c, let's use Roman numeral 4 as an example. You need the consent of both parents for an application for a passport. Why do we say that? Well, because subsection 5 says, unless a competent court orders otherwise, the consent of all persons that have guardianship of a child is necessary for those matters. Now you're sitting with, let's use the UK, it's nice low-hanging fruit for an example. Let's say dad is living in London with a minor child, mom is in South Africa. Dad needs to now go to the embassy to have a passport done. One of the safeguards we have is there's the Home Affairs Affidavit that needs to be signed, and now mom has to contact dad. I need certified copies of your ID. I need a consent form signed, and. Now you have to courier it from South Africa to England. Now you have to hope the person at the embassy who's dealing with it is clued up. Well, presumably they would be, but think about smaller countries. Let's talk about Ethiopia, for example. Let's say there, for example, we might have a consulate, a small consulary office, and not a proper embassy. Now they don't understand what's going on. They don't know how to apply the rules, and you're sitting with huge problems. So in general, it sometimes is easier to simply terminate the 18.3c4 responsibilities and rights of the parent staying behind. Obviously, guys, if you are mediating these types of things, and I would love to hear from some of you who do deal with it or have dealt with it. I see Alfred is no longer with us. Oh, Alfred, you're back. Hey, I'd love to hear from you a little bit later if you've dealt with these types of things before and how you dealt with it. If I may pick on you very, very non-apologetically, you would have to put safeguards in. Otherwise, you are sending a child out into the wild blue yonder, and parent A might not know where the child is going to end up. The last thing on this, which I want to just deal with, Adra, we're going to quickly touch on your question now and discuss it. I'll tell you about that shortly. In terms of consenting to the child's departure or removal from the Republic is South Africa. So once the child is outside of South Africa, Amy, please pop us in a meeting. Once the child is outside of the Republic of South Africa, no further consent is required. So it really is the 18.3c4 which is problematic. Adra, can I ask you, if you don't mind popping your mic and your camera on, just to explain, just elucidate a little bit on your question so we can debate it?
Yeah, hi. You know, I thought that I'm just kind of wondering how these things work in practice, because you just mentioned something about trying to work around it or something like that. I mean, as far as I know, you know, in those 5 instances, you know, I mean, it's something that you cannot go around. I mean, that is, you know, as long as people have got parental responsibilities and rights, then they need to be, you know, involved in those 5 instances, because there are such a serious aspects. Absolutely. But yeah, I suppose that you could, based on subsection 4, I don't know, how does it work in practice?
Sure, I've got your. I'll tell you in practice previously. Okay, so I'm going to give you guys a sneak peek of one of the things that I do in my Children's Act webinar. Adra, you haven't attended that yet, hey?
No.
All right, so I'll give you a bit of a shameless plug. Come swing by and we'll go through it in detail. But I can tell you how I dealt with it previously in a case where dad was here and mom was wanting to immigrate with a minor child to Scotland. And we got it right that way. Incidentally, when I was there many years later, she took me on a pub crawl to say thanks. So that was fantastic. But here is how we did it. And your answer lies in section 28. Termination, extension, suspension, or restriction. So a person referred to in subsection 3 may apply to a high court, a divorce court, or a children's court for an order suspending for a period or terminating any or all of the parental responsibilities and rights which a specific person has in respect of a child. Then basically how we did it in that case is we did a settlement agreement between the two, where dad said, look, it's fine, you can go, and I'm happy with it. Terminate my section 18.3c 3 and 4 parental responsibilities and rights. I still maintain all my other responsibilities and rights except for those 2. And we then put safeguards in. A warning on that, though, guys, if any of you are going to do it, consider subsection 4 of section 28. The court will look at the best interests of the child. The court will look at the relationship between the child and the person whose PR and R are being challenged. The court will look at the degree of commitment the person has shown, and it will look at any other fact. Now, obviously, we all know the best interest of the child standard is very, very in and of itself. So if I quickly go to my the training manual that I use for the Children's Act course, can everyone see my Adobe?
Yes, yeah.
We actually deal with it. Right, we deal with it quite in depth in terms of international relocations. And one of the things that we look at there is a relocation by consent. Now, this is the affidavit that I did for these parties. This went through South Gauteng. The parties were settled. It was approved by the family advocate. It was made an order of court in South Gauteng. I don't know if it will go through the family advocate now with our new friend at Joburg office, who will also be getting a thank you letter. Not really, but who's a big thorn in the side for a lot of attorneys at the moment. However, look at the acknowledgements that we've put in here, Arda, in order to get the termination. I acknowledge that it would be in the best interest of the minor child for the following reason. The mother has traditionally been the primary caregiver, which care includes emotional, intellectual, financial care, and. Child has been primarily resident with mom. I've had limited contact, and. We went through all of these various things, and the court was fairly satisfied with this. The one thing that I would put as a caveat to that is, at the very, very, very least, if you don't get a full expert report, do a Section 10. If you want to terminate for purposes of an overseas relocation to load shedding, so she'll probably be in with us shortly. Arda, I hope that answers your question.
Yeah, thank you. Thanks a lot.
No problem at all. Guys, if you are doing this, remember you do not want to send a child off into the wild blue yonder with no mechanism for the other parent to know what is going on in the life of the child, and. So put very, very big safeguards in your parenting plan or in your settlement agreement, etc., if the child is going to immigrate. All right, we are an hour in. We've got 11 slides to go. Great, so let's talk about, we're going to get back into it. Chante is going to go into a bit of the nuts and bolts. So for those of you who do international divorce, mediating settlements between people outside of South Africa and inside of South Africa, this is very, very relevant as to how it's going to take place, just the nuts and bolts of getting the matter finalized through the courts. And for that, I'm going to hand over to Chante, who's going to be speaking about edictal citation and substituted service. Thank you. Over to you, Chante.
Thanks, Mervyn. Alrighty, I'm just quickly gonna, sorry, wrong way. Alrighty, so first off, we're going to look obviously at edictal citation and substituted service applications. So in a divorce action, the court will request that a summons be personally served on the defendant, right? So therefore, the summons cannot be served outside of the Republic of South Africa without the court approving it. So when a summons is instituted to commence divorce proceedings, it will in essence change the status of the parties, right? So that being from married to divorced or unmarried or whatever the case may be, right? So therefore, there is this requirement for personal service to take effect in a situation like a divorce because it changes your status, right? So whether the defendant will reside in South Africa or outside the borders of South Africa, a summons for divorce must be personally served on the defendant. So unless the court makes an alternative order. Now, I will get to this shortly, right? So let's look at the two scenarios that we are dealing with on this slide. We have edictal citation on the one hand, and we have substituted service on the other hand. So an edictal citation application is an application that you launch at court when you have your notice of motion and your affidavit. So you're going to do an affidavit in your client's name, right? When you seek leave from the court to serve the summons outside the borders. So let's say you have wife residing this side, husband residing in New Zealand. Now you need to serve that summons on him personally. But before you can do that, you need to ask the court permission, so to say, that you can serve the summons on him personally, but outside the borders of South Africa. Alrighty. Now, in most cases, and specifically divorce cases, right, the edictal citation application will usually be accompanied by something we call a substituted service application. So what a substituted service application is where you actually ask the court if you can serve this summons on the defendant by way of email or fax or Facebook, and I'm pretty sure if you can motivate it, you can serve it via Twitter at this stage, right? So Section 44 of the Superior Court Act actually deals with what a substituted service application is and what it needs to, entail. Okay, so what I'm trying to say is basically that an edictal citation application goes hand in hand with a substituted service application. So you're going to be approaching the court to ask them and to give you leave to actually serve the summons no longer personally, but that you actually serve it on them via email. Now, the nice thing about this Section 44, it actually specifies that if you serve a summons, for example, by way of email in a divorce action, now in our instance, right? If you serve it via email on the defendant, that summons will still have the same full force and effect as if it was personally served on the defendant. All right. So if we look at the process and what the process entails when approaching the court for an edictal citation application as well as a substituted service application, we're going to have to look at something that, which I mentioned earlier, is the affidavit, right? So you're going to do an affidavit in your client's name, and you're basically going to explain to the court why you want to serve the summons outside of South Africa. So it's basically going to be the defendant resides there, has been residing there for how many years? And then you further can explain to the court the reasons why you actually believe that the summons can be served via email. So usually what I do in an application like this is, specifically if we're dealing with a defendant who's quite active on his email, I'll attach some correspondence and I'll explain to the court, look, it's clear he is active on his email. We know he's going to get the summons, so there shouldn't be any problem whatsoever. All right, so we deal with mostly in these cases two instances. We have the scenario where the parties have signed a settlement agreement. So they have actually, come to an agreement on how they want to deal with this divorce and what's going to happen to the children and the whole scenario, right? So what I usually do, if the parties have signed a settlement agreement, I'll get the defendant to do something that we call a confirmatory affidavit. So in this affidavit, and I attach it to this whole application, but in this affidavit, I have him explain basically that one, this is my email address and I am active on this email address. The parties have signed a settlement agreement and he's more than happy to actually have the summons served on him via email. The second scenario where we can use this is, for example, where that your husband might be living in Timbuktu, right? But you don't really know where. So it's a case where he's kind of in that area, but you're not quite too sure, but he's bombarding you with a bunch of emails and WhatsApps. So you have an email address for him and you have a WhatsApp address for him. And maybe, I don't know, he's still active on Facebook. So that's the second scenario. You don't necessarily know where he is, but he is active on these social media platforms. Then you can approach the courts and say, listen, I want to serve the summons. I think he's outside of South Africa in Timbuktu. I have all of these email addresses and contact details for him. I want to serve it on him via Facebook, via WhatsApp, and via email all at once, right? Now, I must say, since lockdown started last year, succeeding with an edictal citation application and substituted service specifically is a lot easier. And the reason being, obviously, some countries have lockdowns, so you're not really sure when you'll be able to serve these documents and whatever the case may be. So the edictal citation applications and substituted service applications I've done since lockdown, they all have been granted and allowed me to serve it via email, and not necessarily that I now have to approach the consulate, for example, in Australia to have the summons personally served by a person holding the same, like rank as a sheriff in South Africa to go and serve the summons on him personally, So that's a very interesting part, and it's quite nice not having to stress about it, So not thank you to Corona, but thank you in that regard. The court process has been a lot easier. So when we're looking at the second portion here, which is lodgement at court, right? So you're going to do this affidavit, you're going to take it to court and get it issued, so meaning you're going to get your case number. Then you are going to basically await a date. Now, depending on which court you are, whether you're in the magistrate's court, they still do it the old way. I like to call it the old-fashioned way, where you actually have to go to court and obtain a date for your matter in order for it to be heard. Now, if you're dealing with a case where you're lodging it out of high court, specifically in our Pretoria or Johannesburg, because they deal with case lines, the process is obviously going to be a bit more different, because you're dealing with an online system, which honestly, in my opinion, is a lot more efficient and a lot better, because you don't need to travel all the way to actually get yes, sorry, I just saw your question there. Yes, you can get a substituted service application order in South Africa as well. The reason why I'm saying that is if you are dealing with a case where the husband and wife were married 10 years ago, but 5 years ago the wife just disappeared. The husband does not know where the wife is. They were possibly married in community of property, so he can't even purchase a property on his own name without having the consent of his spouse, but he doesn't know where she is. You can actually approach the court for a substituted service application in South Africa. So yes, you can do that. All right, I hope that answers your question. So yeah, so what I was busy saying is basically with case lines being the online pleasure Stella. So with case lines being the online system that Joburg and Pretoria specifically is using, the process have become a lot easier, because you don't necessarily need to travel up and down to obtain a hearing date or whatever the case may be. But in essence, the nutshell is going to work as follows. You're going to draft the affidavit in your client's name. You're going to send it through to court to be issued, obtain a court date, present your matter to the judge or the magistrate in court on the day, and then they will make an order. The moment that you receive that order, you are actually going to serve it on the defendant. So if the court said it's fine, you can do it via email. You're going to do a nice little email setting out that here's the court order. We've been, granted leave to, serve the summons on you via email. So here's the court order, here's the summons. And then usually, depending at what the order specifically says, the court usually affords the parties 30 days to file their notice of intention to defend, should they wish to defend it, right? If the parties have signed a settlement agreement, you literally, unfortunately, just have to wait that 30 days until such a time that you can apply for a date then for the actual divorce. So that's in a nutshell, more or less, the process that we are looking at. And I just want to make sure, I think the Hague Convention, Mervyn, I don't know if anybody has any other specific questions on those portions raised.
Yeah, I think I'm ready to go into the Hague and the enforcement stuff. Very, very, very problematic, interesting stuff. Unless there are any questions, shall we field a few comments, queries, suggestions, stories, jokes? No, maybe not jokes. That's not Friday. We had a very interesting case. It wasn't Chante's case. It was one of Lee's cases, where the mom hadn't seen the child's dad for nearly, I think it was 11 years or something like that. And they wanted to terminate the father's parental responsibilities and rights. And the dad had also just disappeared. And we had to do it in this way, Stella, to go back to the question that you asked. We had to go through the route of substituted service after trying a few times to serve with the sheriff, couldn't find him, launched a substituted service application, got an order to serve by publishing in a newspaper circulating in the area where he was last known to be resident, and then also serve on him via Facebook. And that just actually finalized. It was a big slog. Shame it made poor Lee old before her time, but eventually they got the substituted service order through. They got it served via publishing in the newspapers, and went through the family advocate, got the endorsement, and eventually Dad's parental responsibilities and rights were terminated after almost a decade of not seeing the child. But well, it was round about there, 8 years, 9 years, 10 years, something like that. But it took us about a year and a half to get the matter through court with a substituted service, sending out the sheriff right, enforcement. So who here is familiar, by show of hands, with the Hague Convention on the civil aspects of international child abduction? Right, so Hague Convention matters are matters that you see very, very frequently in the urgent motion court in the High Court. Especially over Christmas time, you see a lot of Hague matters taking place. And basically what the Hague matters refers to is where a child is taken unlawfully outside of the Republic, the mechanisms to get the child back into the Republic. The convention was signed by a number of countries. I'm not going to go into the history, but I'm going to briefly tell you how it works. And yes, South Africa is a signatory to the Hague Convention, with a whole laundry list of other countries. As you can see on this slide, we have, I think it's 137 signatories to the Hague Convention or something like that. Anyone who is that way inclined, welcome to go and count the number of countries. But most of your major Western countries are signatories to the Hague Convention. Be aware, guys, mediators among you, that this exists, and if a party threatens in mediation, I'm going to grab the child and do the runner, then you have to tell them that they can be liable to some sort of hardship under the Hague Convention. So how it basically works is any state that becomes a signatory or a member of the Hague Convention is duty bound to set up what's known as a central authority. Now that central authority is delegated the function of tracing and tracking down a child in the Republic and securing their return. Okay, so in South Africa, the chief family advocate is designated as our central authority. So if a child is kidnapped and brought to South Africa, the chief family advocate will then be the chief functionary to coordinate the locating and return of the child. The central authority insists in both in outgoing cases, that's when a child has been wrongfully taken from South Africa or retained in a foreign country, as well as incoming cases when a child has been wrongfully brought to or retained in South Africa. A party may apply for the return of the child or access to a child to the central authority. In practice, what we see is people go to the High Court under the Hague Convention and they ask for an order that the central authority be ordered to liaise with the central authority in another country to bring the child back to South Africa under the Hague Convention. Yes, Arta.
Yeah, thanks. I just wanted to find out, you know, the word child abduction and kidnapping is often like used interchangeably, yeah, what would you say is the difference, or is it indeed okay to use them both?
Sure, that's a very interesting question. I must be honest with you, I don't have an authoritative source that I can quote to say this is the answer to the exclusion of all others. Kidnapping, I think, is more of a criminal offense and has its own definition under criminal law, whereas I think abduction can be much more widely interpreted, i.e., even a parent can abduct a child. So let's say, for example, dad takes the child and does a runner to let's pick on the UK again. Mom is left behind in South Africa. Mom would then go to the central authority and say, my child has been abducted by the father to the United Kingdom without my consent. I want an order for them to come back. A very, very interesting question, hey? I'm not 100% sure what the answer is to that. Any other questions on the Hague Convention?
Thanks, hey.
No problem, anytime, Marta. Yeah, guys, know that the Hague Convention exists. You don't need to know all the ins and outs, but know that it is something that exists and that is used from time to time. And you will see most major countries are really signatories to the Hague. There are a few notable exceptions. The United Arab Emirates, for example, are not a signatory to the Hague. A lot of the Sharia law countries, if we can refer to them as that, you know, so a lot of the Middle Eastern countries that are governed by Sharia law are not necessarily. There are some notable exceptions. Let's quickly go through them. I think the only one, I think Uzbekistan still has some Sharia law. I don't know if they are the dominant power there, or whether the communist influence there has done away with it. Turkey, Turkmenistan, to an extent, but if you think of your classic ones, UAE, Dubai, Qatar, they are not signatories to the Hague Convention, and indeed we very frequently see people doing a runner to those countries specifically. Then we look at international issues in maintenance court. To those who were in our maintenance webinar, it's a little bit of duplication. We have various states in respect of whom we have maintenance, reciprocal enforcement agreements: Australia, Botswana, Canada, Coco Islands, Cyprus, Fiji, Germany, Guernsey, Hong Kong, Isle of Jersey, Isle of Man, Kenya, Lesotho, Malawi. I'm halfway through, so I might as well go on. Mauritius, Namibia, New Zealand, Nigeria, Norfolk Island, Sarawak, Singapore, St. Helena, Swaziland, UK, which obviously includes Northern Ireland, Scotland, and Wales, the USA, but only California and Florida, Zambia, and Zimbabwe. We have reciprocal maintenance enforcement agreements with these countries, where a maintenance order granted in South Africa can be enforced there and vice versa. Yes, Arda, you've got a question.
Yeah, you know, it is to me so strange that the Netherlands, my home country, you know, is kind of so like funny in this respect, you know. Yeah, there are lots of issues. Every now and then you hear you know, they're part of the, you know, the Hague Convention, but not necessarily other important documents, treaties.
Absolutely, it's very, very interesting. You know, I think if one has a look here, with the exception of, I think, Germany, and I think it's only Germany, we see a very distinct lack of EU countries on this list. Isn't that striking, hey? Obviously, the UK was what used to be after the very, very messy divorce that they are still busy trying to sort out there. But very, very interesting. And I think this also ties in with what we said earlier, is the whole idea of cooperative governance between jurisdictions, and the formation of blocks. You know, we do sit with the EU, and everything that happens outside of the EU ain't the problem of the EU, to an extent. Now, I'm not anti or pro EU, but it is very, very interesting. What we must also understand, and I say this respectfully to my country as a huge patriot of South Africa, we are, in the grander scheme of things, but a backwater, small country with not much bargaining power. So it could be that some more strong dominant powers don't really feel the need to engage with us, but that's just my opinion. I don't really base that on anything. But Arta, as you say, it is funny that we don't see the Netherlands there, obviously sharing such a history with the Netherlands. But yeah, that's reciprocal enforcement of maintenance orders. And then yeah, we had a nice quick one today through the issues of domicile, service, patrimonial consequences, some stuff with kiddies, and then we're going to go into a bit of a Q&A. Chante, if you can pop your video back on, if possible, if bandwidth allows. Stella, I see you've got a question for us.
Yes, thank you, Mervyn. Thank you, Chante. This has been very interesting.
Thank you.
I just want to ask, because I'm actually busy with the mediation case where the parties wants to get divorced. The wife is a bit stalling because she said to me she's worried because they've been separated now for 2 years. And he's moved on, got a new boyfriend, etc. But the problem is the child, when the child went to visit the father, he mentioned something that he wants to immigrate. And she is now concerned about the maintenance. You know, that once the divorce is through, he's got his money because she's keeping the house, needs to pay him out for the house, and then he's going to leave the country, and then she's stuck with looking after the children. So I just want to find out on a practical note, you know, how would it work? You know, should he then immigrate? What's the procedure for her to get maintenance if he doesn't pay? Thank you.
Absolutely. Okay, so do we know where he's going, Stella?
You know what? She did mention it to me, but I forgot. I will have to go back and ask her.
That's fine. Look, if it is in terms of one of our reciprocal enforcement agreements countries, you know, then she should be fine. Then it will be open quote, close quote, easy for her to have it enforced. And I say open quote, close quote, easy because you have to work through the minister's office. And I think that in and of itself might be like swimming through molasses. You have to go through the ministry this side, then they need to liaise with the ministry that side, which is also bureaucrats. Then they have to serve it that side, and then they have to come back this side. It's a big mishmash. Let's quickly have a look at the chat. I see Emma said, what about a lump sum at divorce? That could be feasible, if possible. The other option, which we've done before for some sort of security, is if you look at policies that parties can take out, not an insurance policy like an investment, or they can sign over an asset, for example, as security, a portion of the pension fund, and. I think your answer in this case, Stella, is going to be very practical in nature, depending on where they are going to go. But you would have to put in safeguards, in my opinion, whether it is a lump sum or an asset that can be placed in trust or escrow or something like that, pending the fulfillment. Chante had a very interesting case years back where the one party, and Chante, I can't remember if you remember the James matter. The dad couldn't pay, and it was foreseeable that he couldn't pay, and they then executed against his pension fund.
Yes.
And they actually took an amount equal to like 10 years future maintenance. And client was very, very chuffed until they bloody paid it into the Guardian's fund. Now the client's like, no, it's, you know. Mariki says, add a clause to the agreement that should he leave the country, he has to pay the lump sum. Yeah, that's a lekker idea there. Mariki, jy is mos die Vrystaat, nee?
Dit sal korrek wees, ja.
Jy's in Bloem.
Ja, maar ek travel graag.
Nee, yes, ek wou sê daai vars lig is goed vir die brein, man. I think that's a great idea. Put a clause in the agreement. We go on as it is. However, should he leave the country, he would have to make a lump sum payment. The thing is, he could do a runner and leave the country without informing your client, but that would be patently stupid, obviously.
Maar dan kan 'n mens dan die authorities in kennis stel dat hy nie die land mag verlaat nie.
Ja.
Dit met die insolventie, so jy kan dit seker met die ook doen.
Yes, absolutely.
Okay.
Very interesting. Like a solution. Stella, I hope that helps, eh?
Yes, thank you. Thank you, Marieke.
Sorry, can I just ask something?
Yes, you're welcome to, Arda.
How can you actually prevent somebody from indeed leaving, or even with a child? Because we have had a few examples that, for example, the child was removed from Holland to Syria without the permission of the other parent. Now, stuff like that, you know.
Yeah. Look, in the South African context, in terms of parents, it's a bit difficult because you wouldn't always know when they would want to go and. With kids, it's fairly simple. Kids under 18 leaving South Africa, they are fairly strict at OR Tambo, or they should be in essence. I remember my wife and I traveled with our infant just before COVID hit. And they were very strict on it. They wanted to see the birth certificate with both of our names on it. They wanted to see both our passports and our IDs and. If you're traveling alone, you would need the Home Affairs affidavit signed by the other holder of parental responsibilities and rights no more than 3 months before your date of travel.
Yeah.
To prevent someone else, for example, and I haven't done this before. I don't know, Marieke, if you've done this previously, but one could potentially, since the settlement agreement, once you're divorced, would have the effect of an order of the High Court. Let's say it's a High Court matter. You could put in an agreement that he is not permitted to immigrate unless and until this and this happens, and the parties agree that a copy of this agreement will be lodged with Home Affairs or with whatever, but the enforcement of it's going to be very, very difficult. You know, I think it can be very, very tricky because the person sitting at OR Tambo might not know that. Unless, is there a flag that they can maybe put next to the person's name? Marieke, are you aware of something like that?
Mervyn, we do that with the insolvents. They do flag the people. And so the moment they try to go through border control, then they just stop them there. And they say, no, you're not allowed to leave the country, because if you hand in that court order by the police, the moment you have your suspicion that your person is going to leave.
But how do you organize that then? How can you have somebody flagged?
You work through the courts, just ask them at the general office and they'll assist you.
Sure. And you say the actual flagging is done by the police. Is it done on the CAS system?
I'm not quite sure what system they use. We just did that the other day with a runner that we had. And then we just went to the High Court saying, yes, our court order. This guy's not allowed to leave. He's insolvent. Please assist us. He's not allowed to leave the country. And they stopped him at Oliver Tambo.
Yo, mooi man. Well done, Marieke. Sure. Thanks for sharing that. That's very, very interesting.
Yeah.
All right, let's go. Before we go into any further Q&A, from my side, thank you so much to everyone who has attended. Chante and I really, really do appreciate it. Chante has really put in a lot of effort putting this presentation together, and I applaud her. Thank you, Chante, for that. We will probably be running this presentation again in the new year once or twice. I think this is probably going to be one of our last ones for the year. Next week, I'm assisting, or I've been asked by Sam to be one of the speakers at the Mediation and Diversity Masterclass. That's next week, Thursday and Friday, so go check out on Sam's website. That's going to be very, very interesting. And on the 19th, I'm running my Children's Act webinar, which is a full-day course. I know some of you have attended it. Renelle, I know I've seen you there previously. Stella, I think you've also attended, hey? Yes, yeah, you were at my very first one, Stella. So I'm running that again. For those who are interested, I do have 1 or 2 seats available. It's 5 SARM CPD points. The cost is $575 for the day, and it includes a handbook with all sorts of interesting material. Last shameless plug, if I may be so bold, in Joburg, please, anyone who needs some assistance with divorce, children's matters, maintenance, domestic violence, please do give us a call. As I'm sure you can see, international divorce really is Chante's bread and butter. She's become very, very astute with it. So please do take down her cell phone number. Just please do not give it to your clients. Chante's Baba has just turned 1 year old, so well, I'm running after toddlers, she's running after infants. You take look your blossom. See, here's my little one. Have you got a box? Okay. So thank you so much from my side for everyone who attended. Let's go into some Q&A. Please don't be shy.
Hi.
Hello.
I just wanted to mention, I just got a WhatsApp about that diversity that is taking place soon. And I think it is quite interesting to attend. I don't know whether what the price is, but yeah, so I don't know. I've got the WhatsApp that I received, and I don't know whether everybody else that is attending this event, whether they've got the number or have received the notification for this. What is it? Webinar for when is it?
Is it the SARM one, or is it the? Are you talking about my one?
Yeah, it's on the 11th and the 12th.
Okay, so this is a SARM conducted master class.
Yes.
Yes. So you would have to chat through with SARM. What I'll do for you, I'll quickly share it here. Stella, do you maybe just from a SARM Exco point of view, maybe just want to let Ordinarily know that some people are asking about the costs, etc. Maybe they can just share it. I've shared the link onto SARM's website for you. It is going to be a fantastic webinar, hey? If I look at some of the names that are going to be speaking, just hearing from guys like Martin Strauss and Robin Fasser is going to be absolutely incredible. I'm going to be sharing, I'll give you guys a bit of a sneak peek. I'm busy with a case now where my client is a trans man who is married to a woman in terms of customary law, but the customary marriage was never finalized, and they've got kiddies together in terms of an in vitro surrogacy type of thing. And we are now negotiating my client's parental responsibilities and rights because he's been dad since 3 years, for 3 years now. But the Children's Act says a biological father. It's a big problem that we're faced with in terms of the law not sufficiently protecting the diverse groups of people that we have. So it's going to be very, very interesting on how do we deal with diversity. Awesome. MI, thanks. Also shared it with us. And yeah, then from my side, obviously the Children's Act one, which I really always enjoy presenting. It's a lacquer chat, very, very practical. So if anyone is keen on that, please do let me know. Marika, I've sent you the link. I see you popped me a WhatsApp as well, so we'll also chat. Yeah, any questions based on today's presentation? Any comments, queries before we all go and hit the pub for a cold one on a Friday afternoon?
It was very interesting. Thank you very much.
Thank you, Art. I really appreciate it. Guys, yeah, I think in closing off, international divorce, it is a hornet's nest. You know, we are dealing with bargaining power between countries, hey? It really is very, very interesting, especially if we look at the reciprocal enforcements of these agreements. The very few countries we actually have agreements with, because obviously we don't have that type of bargaining power. If we look at countries like Australia who just refuse to acknowledge our anti-nuptial contracts, it is a global phenomenon. It's very, very difficult. If we look at the Lacuna, for example, that Chante raised earlier, the loophole of people not being able to get divorced in Korea in a same-sex marriage, we do see this disparity in the laws between different countries. So, what is the conclusion? If you are overseas, don't get divorced? No, not at all. Make sure that you get the right advice. And I put this as an open invitation to all of you guys out there who are mediators. If you ever get stuck with these types of things, please do contact Chante and I. We're always happy to help and give you some information. These matters must be dealt with on a case-by-case basis, and we must always find practical solutions to assist our clients. So I'm going to say the 3 words: going, going, gone.